Welcome to part 4 in our legal title series, When They Stay Silent, Escalating Your SAR Lawfully. In this presentation, we continue from where we left off after SAR 1, the initial subject access request has been sent, but either ignored, delayed, or inadequately answered. This video focuses on how to escalate lawfully, step by step, through formal written notices, always relying on your legal rights under the UK GDPR and Data Protection Act 2018. The aim is not to threaten, but to assert your right to transparency using established legal mechanisms. Importantly, nothing in this presentation is legal advice. This content is provided strictly for public information and educational purposes only. If you are involved in any legal dispute or proceedings, you must conduct your own research and seek professional legal guidance. We are here to explain legal principles in a clear, structured way, not to tell you what to do, but to help you understand the framework behind lawful escalation. Let's begin. So, you've sent a subject access request, your SAR one. You've followed the law, you've asked clearly and calmly for a copy of the personal data a company holds about you. You've requested the lawful basis they rely on. You've exercised your legal rights under Article 15 of the UK GDPR. And then silence, or worse, a vague, evasive response. Maybe they say we're looking into it and nothing comes. Maybe they reply with a generic document that doesn't address your request at all. Or maybe they just ignore you completely. This is where many people stop. But this presentation is about what comes next. The lawful, structured, and entirely reasonable way to escalate when your SAR is met with delay, deflection, or denial. The debt collection agency you see on this slide may look exaggerated, even cartoonish, but the message is serious. Silence is not compliance. A non-compliant response is not a lawful response. The General Data Protection Regulation in UK form is clear. When a controller receives a valid SAR, they have a legal duty to respond. That duty includes confirming whether or not personal data is being processed and, if it is, providing access to it, including information on how and why it's used. If they do not respond at all, or if they issue a reply that dodges the key points, then escalation is not only allowed, it becomes necessary. This presentation walks through that escalation process step by step, not to fight or threaten, but to document, clarify, and pursue the legal transparency you're entitled to. So if your SAR has been met with silence or with something that doesn't meet the standard, you're in the right place. Let's explore what lawful escalation really looks like. Before we move forward with escalation, let's ground ourselves in the legal foundations, because everything in this series flows from the principle of lawful ownership and lawful processing. First, debt is property in law. Specifically, it is classified as a chosen action, a form of intangible personal property, and under Section 136 of the Law of Property Act 1925, legal title to that debt cannot be assigned casually or implied. The assignment must be absolute, it must be in writing, it must be executed under the hand of the assigner, and notice must be given to the debtor. Without those 4 conditions being satisfied, no legal title has passed, and therefore no legal right to act on that data or enforce against the individual arises. It is not a coincidence that the debt collection industry always leaves the line out regarding an assignment must be executed under the hand of the assigner. This is backed up by the High Court Chancery case Frischman v. Vaxil Holdings from 2023. If an assignment is not under the hand of the assigner, then no legal title passes. That leads us directly to data rights. Because when an organization holds or uses your personal data, they must have both a lawful basis and a lawful reason. That requirement is set out under the UK GDPR, and more specifically Article 15, which provides you, the data subject, with the right of access. Article 15 gives you the right to know whether an organization is processing your personal data. If they are, you have the right to know what data they're processing, why they're processing it, who it's being shared with, what legal basis they rely on, and how long they plan to keep it. This is not a favour or an informal courtesy. This is a statutory right, and it applies just as much to private companies and debt collection agencies as it does to public bodies and regulators. In our earlier videos, we referred to this process as SAR1, the initial subject access request. In that first step, the individual exercises their right to transparency to find out if an organisation is acting lawfully in the way it handles their data. But if SAR1 is ignored or responded to with a vague, evasive or incomplete reply, then we move to escalation. That's what brings us to this point. The SAR escalation ladder exists to turn silence into scrutiny and vague answers into legal accountability. So now that we've recapped the legal principles, let's continue. Slide 4. The law requires a response. Once a subject access request is received, the controller, whether that's a bank, a data broker, or a debt collection agency, has a clear legal obligation under Article 12.3 of the UK GDPR. They have 1 calendar month to respond. That's not optional, and it's not flexible. No industry practice, no workload excuses, no we're looking into it, delays. The clock starts when they receive the SAR. And that response must do 3 things. Confirm whether or not personal data is being processed. If data is being processed, supply a copy of that data and identify the lawful basis they rely on to process it. If they fail to do that within the 1 month period, that's not just administrative failure, it's a breach of the law. UK GDPR doesn't ask for best efforts, it requires compliance. So if you've sent a clear SAR, your SAR1, and received either silence or a vague, evasive reply, we don't wait. We don't pause for politeness or hope. They'll catch up later. The law provides a path forward, and that path is escalation. Not to provoke, not to threaten, but to assert your legal right to transparency under the very same regulation they claim to follow. Next, we begin with SAR2, a formal complaint notice that makes the position unavoidably clear. By this point, the initial subject access request, SAR1, has already been submitted. Proof of delivery has been carefully kept, whether by email, recorded post, or other reliable method. This isn't just best practice, it's vital for showing the clock started ticking. If no meaningful reply has been received, or if the response fails to comply with Article 15, whether incomplete, evasive, or vague, it's now appropriate to escalate. SAR2 is the formal next step. It doesn't just repeat the first request, it explicitly restates the legal duty to respond under the UK GDPR and Data Protection Act 2018. It also makes clear that failure to comply will trigger a formal complaint to the Information Commissioner's Office. SAR2 typically gives the organisation a final opportunity, usually 14 days, to respond lawfully. It demonstrates reasonableness. It builds a paper trail. Most importantly, it shows that transparency is being requested in good faith through the proper legal route. There's no drama here, only documentation. SAR2 is the second step in holding data controllers accountable to their legal obligations. We once again keep track of the time and prepare for our next step of escalation if the corporations continue to avoid their legal obligations under UK GDPR. At this stage, the organisation has been given 2 clear and lawful opportunities to respond. SAR1 requested access to data under Article 15 of the UK GDPR. SAR2 issued a formal complaint notice warning of regulatory escalation. If they still do not comply or respond in a way that fails to meet their legal obligations, we move to SAR3, the letter before claim, also known as the LBC. This is not a casual message. It is a formal notification under Civil Procedure Rules (CPR) that the data subject intends to seek a judicial remedy under Article 79 of the UK GDPR and the Data Protection Act 2018. The letter before claim gives the organisation a further 14 days to provide a lawful, full and compliant response. It also serves a second purpose. It shows the court that the data subject has acted lawfully, proportionately, and in line with pre-action protocols. This matters. Courts expect reasonable steps before any claim is issued, and this letter documents that perfectly. Let's be absolutely clear. The SAR3 has nothing to do with a so-called three-letter process. This is not mythology or pseudo-legal US paperwork. It is grounded fully and firmly in UK law. There is no invented theory here and no attempt to avoid or escape lawful obligations. This is about upholding transparency, fairness, and accountability. Organizations that process personal data must follow the law. This third step, SAR3, gives them a final opportunity to do just that before the matter moves to legal remedy. Calm, clear, lawful. Fully within our rights. We use their rules against them. This is how we checkmate the matrix. For more info and a free ebook on UK GDPR, visit cmtm.club. We now reach the fourth and final step in the escalation ladder. The SAR4, intent to proceed, also known as the ITP. At this point, the data subject has issued an initial SAR, followed by a formal complaint notice, and then a letter before claim under pre-action protocols. Each stage has provided the organization with lawful, documented opportunities to respond and comply with their statutory obligations. The ITP is not a threat. It is not a bluff. It is the final 14-day legal warning issued in accordance with the Civil Procedure Rules, CPR, and the Pre-Action Protocols, PAP. The ITP serves three vital purposes. First, it confirms non-compliance has occurred and is ongoing. Second, it gives final notice that a claim is now being prepared. Third, it preserves rights and formally limits what the data controller may attempt to introduce later. This is where the principle of equitable estoppel comes in. Under estoppel, any document or legal basis that has not been disclosed during the SAR process, particularly documents like an instrument of assignment, be that a deed or other format, or a legitimate interest assessment, cannot now be brought forward at the last minute during legal proceedings. Why? Because the data subject has asked for this information lawfully, multiple times. If the organization has chosen not to disclose it by this point, the law may prevent them from relying on it later. This is especially relevant when a company attempts to assert legal title over a debt, yet refuses to supply the evidence that allegedly proves it. The SAR4 also cites the relevant legal instruments, Article 79 of the UK GDPR, which grants a right to judicial remedy, Sections 167 and 168 of the Data Protection Act 2018 concerning enforcement and damages. Article 82, which allows a claim for material or non-material damages resulting from a breach. The intent here is clear. This is not a negotiation. It's a lawful, final step. The ITP closes the escalation ladder. It confirms that a claim is imminent, and it ensures that the court sees a clear and reasonable record of attempts to resolve the matter before formal action. Once again, this is not about avoiding obligation. It's about demanding lawful transparency, accountability, and compliance from organizations who process personal data. Calm, structured, documented, legal. This is SAR4, the intent to proceed. We use their rules against them. This is how we checkmate the matrix. For more info and a free ebook on UK GDPR, visit cmtm.club. Dear Data Protection Officer, I write further to my SAR request, my formal complaint and my letter before claim. Despite multiple warnings, you continue to process my personal data unlawfully. 1. Summary of legal violations. You have failed to provide a legally executed deed of assignment, DOA, which is required under the Law of Property Act 1925, Section 136. Demonstrate a lawful basis for data processing, Article 6 1F GDPR. Comply with my SAR request within the required time frame. Article 12.3 GDPR. Cease processing despite my formal notice. Article 21 GDPR and Section 99 DPA 2018. Your continued failure to provide a legitimate interest assessment, LIA, as required under Article 6(1)(f) GDPR, proves that your company has never assessed the necessity or proportionality of processing my personal data. This constitutes a reckless breach of GDPR and forms the primary basis of my legal claim for damages. You continue to claim rights over an alleged debt without disclosing a valid deed of assignment, DOA, that links the debt to me as the data subject. You cannot simultaneously assert that you acquired enforceable title to a specific debt, yet deny that you hold or process data capable of identifying the data subject to whom that debt belongs. Legal title under Section 136 of the Law of Property Act 1925 must relate to a clearly identified debt and debtor. If you maintain that the DOA contains no personal data, then either you never lawfully acquired the debt, or you are unlawfully withholding data to which I am entitled under Article 15 UK GDPR. This contradiction fatally undermines your claim and evidences a breach of both data protection and property law. 2. Procedural escalation and intended relief revised. As a direct result of your continued failure to comply with statutory data protection obligations and your ongoing processing of my personal data without any demonstrated lawful basis, I hereby place you on notice that I am considering escalation to formal legal proceedings seeking supervisory, declaratory, and equitable relief. Any such proceedings would be directed to addressing matters including, but not limited to, declaratory relief, confirming that you have no lawful basis under Article 6 UK GDPR to process, retain or act upon my personal data in the absence of proven legal title or a valid legitimate interests assessment, injunctive relief, restraining any further processing, enforcement activity, or third-party disclosure pending full compliance with data protection law. Mandatory disclosure requiring production of documents and records necessary to establish the lawful basis you assert for processing, any legitimate interests assessment relied upon, and the legal authority under which you claim entitlement to process my data. Court supervision to ensure ongoing compliance where voluntary compliance has failed. The purpose of this notice is not to quantify loss or seek summary monetary relief, but to secure lawful transparency, restraint, and compliance in circumstances where continued processing is occurring without any demonstrated legal justification. Your ongoing failure to identify and substantiate a lawful basis for processing, including the absence of any disclosed legitimate interests assessment under Article 6(1)(f) UK GDPR, while continuing to act upon my data, represents a continuing and unresolved compliance failure. This notice is therefore issued to preserve rights and place you on clear notice that continued processing without lawful justification may necessitate court supervision and formal restraint. 3. Final demand before court filing. You are hereby placed on final notice unless I receive a fully compliant response within 7 days. I shall issue a claim in the county court under Article 82 of the UK GDPR and Section 168 of the Data Protection Act 2018, and I shall submit formal complaints to the Information Commissioner's Office and Financial Conduct Authority. This letter forms part of the pre-action evidential record and may be presented in court to demonstrate your organization's failure to comply with statutory obligations. I strongly urge you to seek immediate legal counsel. Yours faithfully. At this point in the process, it's important to step back and reflect on why this structured and lawful approach matters so much. This isn't about creating conflict, it's about demanding accountability. The steps we followed, from SAR 1 through to the intent to proceed notice, are all based on clear legal rights and responsibilities. No threats, no drama, just lawful persistence. If an organization refuses to respond to a lawful subject access request, especially after multiple notices, it may indicate that they simply don't have legal title to the data they're using or the debt they're pursuing. Silence can speak volumes. Transparency is the real power here. By asking the right questions in the right way and using the correct legal mechanisms, you expose weaknesses in the chain of title or process. Sometimes that reveals wrongdoing, other times it just shows that proper records haven't been kept. Either way, it's valuable. And finally, the most important point, the law is your tool, not a threat, not a weapon. A tool. Used calmly, confidently, and correctly, it opens doors and gives you standing. When followed step by step, this process is fully in line with UK legal systems, including the Civil Procedure Rules and GDPR. Remember, the goal is lawful resolution, not conflict. You're asserting your rights, not evading obligations, and ultimately, you decide what to do with the information revealed, whether that's requesting disclosure, filing a breach claim, or seeking injunction relief. So, after all the notices, the warnings, and the opportunities to comply, what comes next? Now we move toward preparing a legal claim. Based on everything established, we are pursuing a claim under Article 79 of the UK GDPR or under the Data Protection Act 2018, depending on which legislative route best fits the specific breach. This isn't a bluff, it's a structured legal pathway based entirely on your rights and their statutory duties. At this stage, we also prepare to apply for legal disclosure under Civil Procedure Rule 23, which allows us to request a court order for the documentation they've refused to provide voluntarily. This includes the instrument of assignment, internal correspondence, and records of data processing. We're also in a position to request equitable relief, or if appropriate, even seek an injunction to stop further unlawful processing of your data. But here's a critical point. We do not want this to be pushed into the small claims track, where disclosure is limited and costs are generally unrecoverable. So, we reference the pre-action protocols, showing the court that we've done everything reasonably possible to resolve the matter out of court. Then we rely on CPR 23 to show that this case should be allocated outside CPR 27, which governs small claims due to the complexity and seriousness of the data breach. This shows the judge that we're not acting in haste or malice. We've followed a lawful, transparent, and persistent path. That builds credibility in court, which is crucial. This is how we go from being ignored to standing in court with the law and the facts on our side. The next video will show the type of replies that you can expect to get from a debt collector when you send the SAR, the obfuscation, and the twisting of the actual law. Also, we will explain how and why many of the mainstream debt collectors do not even have a license to do what they are actually doing. That one you must not miss. This is not a mistake, nor just a one-off with the debt collector that you are dealing with. We have been given hundreds of replies from many debt collectors. We have researched the FCA register over and over. We have the facts in our files, and we will be sharing them with you. We will also be sharing what we are doing about this business model, created from fakery and obfuscation, and what you can do about it too. So see you in the next video of this series. Remember to give us a thumbs up, subscribe, and hit the bell for notifications of the next video. To get a free GDPR ebook, go to cmtm.club.